very generous introduction. It's a real honor to speak at Mackey. This is a center that does fantastic work at the intersection of law and economics. It's been influential for a number of years, and a lot of the publications that come out are always worth reading. So it's almost intimidating to speak to such a distinguished audience. I also would like to start by paying tribute to Heike Schweitzer. When her death was announced, it was a great shock to me personally. I knew her fairly well. But what I want to say today is something about her intellectual contribution, in particular to competition policy. Any of her work that you read will try to hold the center. She had a vision about the nature of European Union competition policy that she felt was necessary to be preserved. And she fought a valiant fight against what I'm going to call the more economic approach fundamentalists who want to reduce competition law to non-existence, and the policy instrumentalists who want to use competition policy to achieve goals that have got nothing to do with competition law. And in much of her work, she tries to hold the middle ground, that there is a particular European economic and institutional configuration within which competition law exists. Of course, she knew it had to develop, but it had to develop on the basis of some fundamental notions and some fundamental concepts and values that animate all of her work. And I think that's the kind of center ground that we need to hold today if competition policy is going to survive against a number of the threats that come in its way. Now, Heike has never really written a paper that I read on merger control, but while I was writing this keynote, I was also over the weekend rereading all of her work that I could and trying to think about her when I was reading it. And a lot of what I say, I think, will resonate with what she has pointed out. So this presentation is based on a paper where I try to take into account all the judgments of the Court of Justice on merger control and try to make sense of what the court has contributed. I'm not going to present all of the paper today. That would take more than 45 minutes, but I'm going to give you some highlights. Let me just start with some numbers first. So according to the database, we have around 9,000 merger decisions given since 1990.
And of these 33 mergers have been prohibited. And of these 33, 15 have been appealed against, and 5 of these have been annulled. So to paraphrase Justice Douglas, the government almost always wins, but loses sometimes. I'm not going to comment on those numbers today, but I find the second number more interesting. There have been 8,828 mergers cleared, and of these, there have been challenges only against 34 of these decisions. Now, over the last 5 years, we've heard lots of papers about there is under-enforcement, the commission allows too many mergers, and yet nobody appeals against this ostensibly very generous commission. And then if you look more attentively at who appeals, the largest number are rivals. Now, rivals are the worst possible appellant because presumably if the merger yields efficiencies, the person to suffer is the rival, and you don't want the rival to be able to challenge a merger which is beneficial to society. You would rather have consumers bring a claim or customers. But as you can see from the numbers, and the number of 3 customers is very generous because when I looked at the facts, one of these customers is actually a rival, but I decided to include him as a customer because he was a potential rival. We have very few cases being brought by the parties who are protected by the antitrust laws, the customer or the final consumer. Instead, the next largest category, which I'm not going to talk about, are the merging parties themselves who are dissatisfied with the merger clearance because they don't like the commitments that have been that they have agreed to. Those cases are all very idiosyncratic and they can be discussed in a separate occasion. I'm going to focus more on the appeals that have been brought against annulments and the appeals that have been brought by rivals. Maybe just one legal point before I get to the economics. Oops. Why do the wrong parties appeal? Why do we have rivals appealing? And why don't we have consumers launching appeals instead? Well, this is just a matter of European law. There's nothing we can do about it to correct the course. When the Commission issues a decision, the decision is addressed to the parties to the merger, who are therefore directly affected and can appeal. They have an automatic right of appeal. But if you're not directly impacted by the addressee of the decision, then you are called a non-privileged applicant. And the question is, are you then directly and individually affected by the decision? If the answer is yes, you have standing to sue. If you're not directly or individually affected, you don't have standing. So rivals, of course, have standing, but not all rivals have standing. So in the early cases on airlines, Air France and EasyJet, the Commission said that Air France and EasyJet had standing to sue because they were affected in a manner which distinguished them from other competitors in the market. So you also have to compete to be the nearest rival to the merged entity to be able to challenge it. Not all rivals are entitled to do so. Those two cases were relatively easy. More complicated was the situation in SEB Mulanex, where it was a merger in an oligopoly market, and there were about 6 rivals, and 2 of them wished to appeal against the merger clearance, and the court had to struggle to find that both were entitled to do so by labeling both of them the principal competitors. So they tried to stretch a little bit the doctrine to say, yes, everybody is affected, but these 2 are special. This rule is very idiosyncratic and makes very little economic sense. Consumers have no right to claim. Consumers, this is quoting from the court, have an objective and abstract status. So the primary beneficiaries of competition law are just not directly or individually affected by the decision. If the price goes up, every consumer suffers, no consumer is special, no consumer can claim. Ditto a consumer association. The claim was brought by the Belgian Consumer Association against the merger in the energy sector, and they said, look, this merger is going to pull retail prices up. No standing. These rules are problematic, but there's nothing we can do to fix them unless we review the treaty. So I'll just leave them there for you to ponder as to how European law can sometimes be mad. I'm going to focus more now on the use of economic tools by the Court of Justice and the European Commission. And I found this judgment, which is purely procedural, contains a couple of passages which are worth reflecting upon because they reveal the respect with which and the legitimacy that economics brings to competition proceedings according to the Court of Justice. So the facts of the case were about the design of an econometric model, which the Commission had done in collaboration with emerging parties. After the collaboration with emerging parties, the Commission changed some of the variables such that the model gave different results, but did not disclose this to the other side, that they changed the model on which the decision was going to be reached. And that was the appeal. You should have disclosed. So the case is purely procedural. What rights does the merged entity have to be appraised of the economic analysis being carried out? But I felt the way the court expressed itself in very general terms, the first paragraph here, the choice and the use of models contributes to the impartiality and the quality of the Commission's decisions, which ultimately is the basis for the trust that the public and businesses place in the legitimacy of merger control. I think this is a really profound statement and surprising that the court would say this, that the use of economics is required for the legitimacy of competition law enforcement. And on the facts of the case, and I'm sorry, somehow between emailing the slides, the font changed. The court concluded that by refusing to share the revised version of the model, you threw into question the basis of the decision because the applicants had no chance during the hearings to contest the validity of the new model. And therefore, when we come to judicial review, we're now handicapped because we don't know what the other side had thought about the model. Decision quashed. So it quashed on a purely procedural matter, but it goes to show the importance that the court places in not only the use of economics, which is fundamental, but also that this use is integrated into the legal framework. Use it, but use it procedurally in a manner that allows for a proper conversation between the Commission on the one hand and the merging parties on the other. On the other hand, the court is also very careful at looking at what economic models are chosen. So in CK Telecoms, the court said, just because you use economics doesn't mean a free pass. You have to convince us that the merger is anti-competitive with a degree of probability above 50%. And here I think Advocate General Cocotte's words are also interesting from a law and economics perspective. She says it's not possible to provide objective proof of a forecast for it to be free of uncertainty and doubts. Thus, we cannot have a standard of proof which is above 51% to something like beyond reasonable doubt or higher, simply because the economic evidence will never be so definitive as to for us to be sure to always be able to condemn. The other point to make is that the court will review the use of economics by the Commission. And the Tetra-Laval judgment, I've rephrased it here in the form of questions, says that judges are empowered to ask the following 3 questions. Is the evidence provided accurate, reliable, and consistent? And that allows the court a lot of scope to question the economic analysis. Suppose you build a model and you say this model is based on these 3 factors, and you've not taken into account factor number 4. The court can say, well, you should have taken into account an additional factor which isn't in your model. Does the evidence contain all the information that must be taken into account? is it capable of substantiating the conclusion? So the court is willing to engage with whether the economic model that is being relied upon is sufficiently robust to yield the result that the commission wishes to see. Conversely, if the parties bring in an economic argument, the court will ask the same thing. So the court is not afraid, at least at first blush, to engage in depth with the validity of the economic argument. And I say this because when this judgment was rendered, Tetra Laval in 2002, a lot of people said, oh, this is not a very demanding standard of review because it's very marginal, it's about manifest errors. But of course, it's about manifest error because the commission has a comparative advantage in deciding how to bring the case and marshalling the economic evidence. So we cannot put ourselves as judges in the shoes of the commission, but we can interrogate the validity of the choices that have been made. And if we feel the choices have not been made accurately, we send the case back to the commission for it to redo its homework. So it's a standard of review which gives a lot of latitude. Yes, of course, it's labeled manifest error, and that supposes a hands-off approach. But if the judges wish to do so, they can use the standard in a very intrusive way to question the approach taken. And indeed, in subsequent judgments, the courts have said, just because something is in the guidelines doesn't make it binding. We can quash guidelines. And I'll use a case now to illustrate the court's power to do so. So one of the important things that came out of the 2004 revision of the merger guidelines is unilateral effects. So what happens when we have a merger that does not create or strengthen the dominant position, but nevertheless causes unilateral effects? The merger regulation requested that the commission come up with a set of guidelines to explain to parties how this new test would be carried out. And I've tried to summarize the elements that are found in the guidelines. Market shares, closeness of competition, ability to switch, competitors' capacity to increase supply, competitive force, and so on and so forth. Now, they are listed in the guidelines in a fairly random order without any explanation as to whether all of them are relevant all the time. And so it wasn't really clear how the commission was going to play with the various factors that it had listed. Now, the reason they're listed in this way is because of a previous judgment of the General Court where they said, if you write something in the guideline, don't feel obligated all the time to follow all of them as if they were a checklist. You've got to contextualize the facts into the case. And so I guess the commission felt, okay, let's contextualize and not give a lot of explanation beyond just the factors that are to be taken into account. Of course, the guidelines are obsolete because a lot of the interesting work on unilateral effects has been done after the guidelines were written. For example, the paper by Farrell and Shapiro in 2010, but there are plenty of other papers one could cite that make more interesting reflections than the ones that are found in the 2004 guidelines, but that's what we got. For a number of years, the existence of this new test meant very little. The commission continued to block mergers or to intervene and seek remedies because the merger would strengthen or create a dominant position. So there was never a position of power without dominance. But in the telecoms sector, the commission was faced with situations with a number of mergers which created a tighter oligopoly. And the theory of harm was not coordinated effects among the oligopolists, but unilateral effects. 21 mergers were notified because the geographical market is national. So each member state is a separate geographical market. So you have lots of cases. And only one of these was prohibited. This was the CK Telecoms judgment, which was appealed. And I'm going to tell you the story of the appeal. So this is a 4-3 merger in the UK market. The merged entity would have had nearly 50% of the market, but would be in no way dominant. There were a number of other effects, but I'm just going to focus on the effect on the retail market. And the commission more or less goes through the elements in the guidelines and find that all of them give an indication that the merger would substantially impede effective competition. So the change in market share was quite significant. The target was a lively competitor in the market offering various discounts to consumers. There was a close degree of competition between the two. They do some tests to see where consumers would switch. They run an upward pricing pressure test, which yields a positive result. They look at the role of mobile virtual network operators. These are telecom operators that do not have a network, but they lease the network from one of the major parties. Can they potentially compete against the merged entity? No. Can the other two rivals, Vodafone and BT-EE, reposition themselves strategically to compete more aggressively against the merged entity? Probably not. Commission concludes the merger should be blocked because this is a substantial impediment. I've run it very quickly. It's a 600-page decision. I could spend days telling you all the details. On appeal to the General Court takes the decision to shreds. So I've deleted the bits that they thought were completely wrong and substituted them in yellow by what the court thinks is the correct test. So the target's importance as a competitor is the wrong legal standard. The standard is whether the target, it is an important competitive constraint. And this is essential. If the target is not an important competitive constraint on the merged entity, you don't block the merger. Closeness of competition? No, 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 no. The rival has to be particularly close to the other party. Just a degree of closeness is not enough. They have to be the closest rival. Yes, you can run a UPP test or a variation of the upward pricing pressure test, but you've got to factor in an efficiency credit. Otherwise, the result is always positive. Moreover, yes, of course, look at potential competitors, but what is really vital is that you need to make sure that the effects of the merger reduce competition across the industry. So just because A and B, the merged entity, stop competing and increase prices of one of their products is not bad enough. You've got to demonstrate that the industry prices will go up. And only if you prove that secondary effect can the merger be blocked. And the Commission said that otherwise, unless we tighten the Commission's rein, the Commission would systematically prohibit all horizontal concentration in an oligopolistic market. Now, that statement is just absurd, right? The Commission has allowed all the mergers in the telecom sector before, has allowed 8,820 and has blocked 33, a couple in oligopolistic markets because of coordinated effects. So this is the first case that they block on the unilateral effects. So the statement doesn't quite resonate very much with reality. But the tightening of the test is something we can discuss. Of course, the Commission wasn't happy with this because it basically handcuffed it to a very narrow standard, so they appealed. And on appeal, the Court of Justice quashed the General Court's judgment, and now we are awaiting a General Court's re-evaluation of the decision. And so they respond to each of the points made by the General Court. The target's important as a competitor. It's about the Commission measuring the degree of importance that this competitor has on the market. They don't have to be the most important, but they have to be somewhat important. And we trust the Commission to measure this accurately. Closeness of competition, yeah, they have to be close, but they don't necessarily have to be the closest. We just need to measure the degree of closeness. The closer they are, the worse the merger is. The less close, maybe the less problems there are. UPP test, we don't want an efficiency credit because we have an efficiency defense. And to prove harm, we just need to prove that the merged entity will be able to increase the prices of both or one of the products. We don't need a market-wide effect. Okay, I summarize, it's much more complicated, but that's more or less it. And the Commission said, the court said, this is the standard because we want to establish effective control of concentrations. And unless we create a situation where the Commission is able to exercise its discretion and use the data correctly, and we narrow them to a very narrow standard, we're not going to get effective control of mergers. We're just going to get every merger being authorized. This judgment is significant because it comes from the Grand Chamber. So the court composes itself into relatively small chambers for ordinary cases, but when the court wants to say something significant, it composes itself either as the full court, all the judges, or the Grand Chamber, 75% of the judges. So that the fact that this is one of the few Grand Chamber cases in competition policy means that the court is trying to send a message about the nature of enforcement. So what struck me, and I wrote a couple of papers, both on the General Court's judgment, which got me very angry, and the Court of Justice's judgment, which made me a little bit less angry, is why the courts differ so much. I mean, how can you be in the same building and reach two such different conclusions? So on the one hand, you can say, well, the difference is simply the difference in view as to how to translate economics into law. We have a lot of economic literature. The General Court says the economic literature teaches us we need to have a very narrow test. The Court of Justice looks at the same literature, looks at the law and says, no, we think that stuff should be translated in a different way. It's just a difference of opinion. And the Court of Justice wins simply because it is final. And its infallibility is just by definition of its finality. But if you look at it more closely, I think the difference is more ideological than just technocratic. So take the position that the two courts have on type 1 errors. The General Court says if we have a looser test, any concentration in a 4-to-3 operation would be prohibited. So they're really afraid that the Commission would unleash its powers and block every 4-to-3 merger ever. The Court of Justice instead has the opposite view. If we don't have a looser test, we risk under-enforcement. We risk underestimating from the outset the competitive forces present within an already concentrated oligopolistic market. So a very different view about the nature of error. The other thing is, if you look at the assumptions that you find in the decisions, the General Court says any concentration will lead to efficiencies. Okay, that's interesting. This is in the context of UPP test. The Court of Justice said, well, actually, mergers may result in lasting damage to competition. So we should really be watchful about merger control. So a very different vision as to why we have merger control. One is, it's almost efficient, so don't worry. The other one, well, actually, maybe mergers are a problem. And then the nature of judicial review is also something, and the attitude of the two courts vis-a-vis the Commission is also something noteworthy. And here, and this is what made me angry about the General Court, I think this statement is not judicial at all. if I were a judge, I wouldn't write that if I did not rule in this way, the commission might classify the facts in such a way as to benefit from the most favorable rules of evidence before the general court. So this portrays the commission as a scheming actor who tries to circumvent whatever blockage we have in order to win cases. Now, you might be cynical about the commission as an academic, and you might say the commission is a political entity which makes decisions based on pressures that come from the various capitals in Europe. But if you read these decisions, they are 600 pages long. They have annexes where there are detailed responses to the economic literature brought up by the two sides. To say that they are trying to scheme their way into blocking mergers when this is one of 33 mergers being blocked is, I think, an exaggeration. But this is the attitude of the court. We've got to be wary of the commission as a decision maker, and therefore we need to tighten control. Conversely, the Court of Justice said our job is to make sure that the commission's interpretations of EU law, which require economic analysis, is implemented in the right way. We'll trust the commission, but we will watch out whether they make a mistake, but we're not going to be paranoid that just because the case is against the commission, we're against a scheming entity that is trying to hoodwink the court into making decisions which are fundamentally mistaken. So I think there's much more division between those three judges in the General Court and the Grand Chamber than just a technical translation of economics. But of course, I'd be interested in knowing what you think about the correct approach to unilateral effects. Intriguingly, 2 years after CK Telecoms, the General Court heard another appeal against the merger in a different sector, the steel sector, Tata Steel, where the commission also prohibited the merger on the basis of unilateral effects. I'm not going to go through all of the decision, it's way too long, but I want to highlight 3 elements of the decision, which I think give us an interesting insight into how a differently composed set of judges handles economic evidence. So one of the applicant's complaints was the commission did not use the hypothetical monopolist test to define a relevant market. They used other evidence, not good enough, you got to use the SNP test. And the court says the commission isn't bound by any test. It retains the right to choose from a range of evidence, whatever it considers to be most appropriate in each individual case. Of course, that choice can be reviewed. The court can say, you've made the wrong choice. This is the wrong model by which to define the market, or this is not the right data. But you've got to give the commission the freedom to choose, and you cannot per se condemn the commission for failing to use a particular test. You can motivate that. You can say, no, you should have used the SNP test, and to use the SNP test, you should have carried out these inquiries, which would have led to this finding. But you cannot just prima facie say the failure to use a particular economic model, which may have been favorable to you, would be an infringement of the law. What about the evidence you use? And here I think it's a nice statement. The commission isn't bound to rely on sophisticated economic studies all the time. If the facts are clear, it can rely on simple economic and commercial realities and reach a decision. So yes, there can be cases where you need a lot of sophisticated economics, where you might need an annex to explain what you're doing. So the case law on the innovation theory of harm, for example, the commission supplements the decision with a long annex reviewing the economic literature on innovation and says, these are the papers which we find convincing, and then this motivates our decision. But if it's in the steel sector, we've got enough knowledge about how the market works, we don't need to deploy the most complicated economic analysis. As Heike Schweitzer put it in one paper, sometimes there are diminishing marginal returns. It's not always efficient to use all the economic firepower you've got if the case is relatively easy. On those two, I think the General Court is sending some interesting messages about the use of economics. But I think, and the last quote I put here goes too far. And this is one thing I have doubts about. So if anybody has ideas, more than welcome. The commission says that the court says the commission cannot be criticized for concluding, right, the decision itself, that a merger can have both harm to competition because of the creation of a dominant position and resulting from non-coordinated horizontal effects in an oligopoly. So the same thing can have these two identities. And if you look at the telecom merger decisions, the commission said this merger can be blocked either because there are unilateral effects or because we think there are coordinated effects. Now, maybe I'm too much of a formalist lawyer, but I don't think these things are consistent. Either the merger creates coordinated effects or unilateral effects. Either it's unilateral effects because you don't have a dominant position or you create a dominant position. There are 3 theories of harm: unilateral, coordinated, dominance. And okay, dominance is also unilateral, but it's a different kind of unilateral than the ones you look in an oligopolistic market. So I think sometimes the commission, I don't have a problem with the commission starting a case saying, okay, we think this merger is a problem. Let's work out if the evidence tells us there's likely to be collusion. Or let's work out if the evidence tells us these are the two closest rivals, as a result of which there will be a price increase. That's fine. You can test for a variety of effects, but when you want to make a final decision, I think you've got to be pretty sure about which of the three effects it is that you want to condemn and which one you want to discount. This approach seems to me to give too much power to the Commission to make decisions which are perhaps internally inconsistent. And I would argue, even with unilateral effects, you can have different categories of unilateral effects that the Commission should pin down. So perhaps a bit too much latitude there, but interested in your thoughts. So that's the story about unilateral effects. And I wanted to move on to a couple of other topics where I think it may be interesting to reflect upon the court's position. Please tell me when I'm nearly out. The first is, as we know, the Commission is always under pressure to allow a merger because it's in the public interest. It may be not in the interest of consumers or customers, but it is in the public interest. We must allow the de Havilland merger because then we have a stronger airline industry. We must allow Siemens Alstom because then we will have a faster, better railway manufacturing capacity in Europe. But the Commission, I put de Havilland and Siemens at extremes because de Havilland is the first decision the Commission blocked in 1992, and Siemens is the most recent one blocked. And the Commission is very capable of resisting an attack from these people who want policy. There's lots of stories about both of the cases where you know that different politicians have put pressure on the commissioner. Both commissioners were able to resist. And one reason they're able to resist is the use of economics. The response is, we've got the guidelines. We cannot make a decision that goes outside the scope of the guidelines. We've got to follow them. Of course, there are some cases where you can be more doubtful. So my favorite is man is man. So you read this decision, it's relatively short. And every paragraph, they're going to block it. They're going to block it. This is such a dominant firm. And at the end of one paragraph, they say, they U-turn. They say, well, actually, we don't think there's going to be a competition problem. So there is a clear case where the politicians intervened, requested the merger be allowed. But there are perhaps 2 or 3 other cases I can think of where you see in the decision something which doesn't compute because the evidence is all going against and then the merger is allowed. But this happens extraordinarily infrequently. But what about more direct references to non-competition arguments? What has the court had to say about this? Relatively little, but I think it's interesting to pick up the pieces and see what we make of them. So in Nestlé Perrier, this is a case about coordinated effects. The parties to the applicants were the employees. And the trade union said, this merger is going to lead to job losses. Job losses are a factor to be looked at in competition law. And the court does not disagree. Competition may, in certain cases, be reconciled in the context of the assessment with taking into consideration the social effects of the operation. The court doesn't say how this reconciliation is to be carried out, but it says it ought to be. However, that seems to be a statement out there that is not consistent with the way the court has done things afterwards. So in Kalyan Salz, which is the decision which certified that there is a failing firm defense, the Advocate General said, well, one of the virtues of rescuing a failing firm is that all the people who would be otherwise unemployed are now saved. And the Court of Justice said, no, that's totally irrelevant. We rescue a failing firm, we allow the merger with a failing firm because the merger does not cause an anti-competitive effect. The social consequences are irrelevant. In the Daimler-Chrysler joint venture decision, the applicant, Qualcomm, observed that the Commission, in rendering the decision, made some statements to suggest that this merger would be beneficial for Europe because it would accelerate the launch of telematic services in Germany, where the market effects were felt, but also in Europe as a whole. And Qualcomm queried whether this was a misuse of powers. You cannot take industrial policy into account. Now, the General Court looked attentively at the decision-making process and concluded, well, no, they considered only competition policy. So they don't say anything about the industrial policy statement, which was seen as an aberration and not in line with the way the decision was reached, nor with the way in which the remedies were designed. But what if it had been? What would the General Court have said? Would the General Court have said, well, we've got to look at the treaty as a whole? If you look back to Nestlé Perrier, I've highlighted some words. The legal test in EU competition law is not, does this harm competition? It's not, does this harm consumer welfare? Is this conduct incompatible with the internal market, common market at the time, because the treaty was older, right? So the fundamental test is not, does this conduct harm competition? Is this conduct incompatible with the internal market? And the internal market is more than just competition. The internal market is also sustainability, full employment, non-discrimination. And so it's not impossible to try to interpret the treaty in such a way as to include non-competition objectives, but we haven't got really very much from the court to tell us how to do so. There are a number of scholars that are working on this, of trying to create a more polycentric, as Professor Lianos has put it, competition policy. So there's literature, but guidance from the court, precious little. There are going to be a couple of challenges to this. The first is that since a couple of years ago, the Commission has encouraged member states to make sure that mergers don't harm strategic national interests. And so that even though the merger may be cleared under EU competition policy, maybe the member state should feel empowered to block it because there is a public interest risk. If the investor is from a hostile state, if it's buying into a particular industry, perhaps we want to allow some sort of industrial policy to protect. And in a recent judgment, Zella, the court explains quite clearly that this is possible. Public policy and public security can be relied upon, but only if the state demonstrates a sufficiently serious threat to a fundamental interest of society. In this case, there was an acquisition of building materials. And the court was not convinced that the extraction of gravel, sand, and clay was of fundamental interest to society. And yet, even though the case is a very simple one, this is clearly a protectionist move by the government to facilitate the survival of a company in its country. The court spends quite a lot of energy explaining that, yes, you can take non-competition interests into account because of national public policy, but the scope of maneuver is very limited indeed. Finally, just to project a future challenge, recently the foreign subsidies regulation was agreed, which allows the Commission a second bite at the merger. The merger may not be anti-competitive, but because the acquiring firm has been subsidized by foreign subsidies, that might have given it a competitive advantage, allowing it to merge. And in these situations, we need to do a balancing test. There can be a negative effect of the foreign subsidy in terms of the distortion of the internal market. Again, not distortion of competition, distortion of the internal market. God knows what that means. But there could be some positive effects. And I'm sorry the slide isn't there, but the positive effects on the development of the economic activity in the internal market and then the relevant policy objectives of the union may allow this merger to, may count for a positive. This is really tough stuff. In merger control, the Commission never balances. The efficiency defense is not about making a trade-off between positive and negative effects. The efficiency defense is saying the merger does not cause a negative effect. So this is the first time the Commission is called upon to balance a negative effect, undefined, with a host of positive effects, undefined. So when this gets to the court, lots of interesting work will be done. And I think economists have a lot to contribute to sharpen the edges of this very roughly drawn test. The last topic I want to talk about is one which is of contemporary interest because of a number of acquisitions that have not been reviewed by competition agencies because they fly under the radar. And the Court of Justice has rendered a judgment in a case from the French Competition Authority, Towercast, where a merger occurred in the French market and the merger was not notifiable under EU competition law. It wasn't notifiable under French merger rules. And the complainant said, you should therefore apply Article 102 because the merger is by a dominant firm buying a non-dominant rival. Therefore, that's an abuse of a dominant position. And the court says, yeah, that's not impossible. Article 102 can apply to acquisitions if the acquisition is an abuse of a dominant position. The court had decided this in 1972 in Continental Can. And in Towercast, they repeat the form of words that you find in Continental Can. I put it there. It must be established that the degree of dominance thus reached would substantially impede effective competition. If you stop there, it's easy. It's the same test as in merger. If a dominant company buys a rival, does that purchase cause a significant impediment of effective competition? Same test as in merger control. And then, of course, the court tries to explain itself in ways which are incomprehensible. That is to say, that only undertakings whose behavior depends on the dominant undertaking would remain in the market. I have no idea what that means. Who are the undertakings that depend on this? Are they rivals? Are they upstream or downstream? Because now they depend on a monopolist gatekeeper. I have no idea what the second paragraph means. And yet all the scholarship refers to this and says the test is therefore very narrow indeed. Yes, you can apply Article 102, but in very limited circumstances, because the court in this passage has said it's only very rarely that you can apply Article 102 to the case. Look at Continental Can, look at Towercast. The problem with this line of argumentation is that people don't read. If you look at the Continental Can judgment, after they make this statement, they say, okay, this is the statement of law. Now let's review the substance of the Commission's decision. And the Commission's decision is very ordinary. They define the market incorrectly, as it turns out, but they define the market. They work out that in this market, there's a dominant player. They work out that if the dominant player buys this undertaking, there is no other rival. There are lots of entry barriers in this market. Buyers have no power. It's a very ordinary merger decision. On the merits, it fails because the Commission defined the market too narrow. But it's a very orthodox application of what today we would call unilateral effects. So the fact that there is this qualifier in the general paragraph shouldn't distract us from the fact that the general test applied in continental Japan is, does the merger substantially impede effective competition? The limit is you can only apply it if the acquiring firm is dominant. But that's it. That's the only limit. Recently, one advocate general, whose opinion I find extraordinarily questionable, has put forward an alternative opinion, which is, if you look at a killer acquisition, these acquisitions are a paradigmatic example of a by-object abuse of a dominant position. So in his view, you don't need economics here. It's self-evident that if a dominant company buys a tiny rival who is going to potentially compete against it, that's a restriction of competition by object. Now, he draws strength for this proposition from the Super League judgments in December 2023, where the Court of Justice said there is a possibility to condemn an abuse of a dominant position without relying on effects if the conduct is self-evidently anti-competitive. And so it creates, in the jargon of many competition lawyers, a by-object category, like you have in 101, object effect, and he transplants it to this. I don't think this has any mileage whatsoever, but I thought it was worth pointing out that some people can go quite wild with loose statements by the Court of Justice. The other point I want to make on this case is, okay, so we now know we can apply Article 102 to mergers that don't need to be notified. But when can you apply it? Now, if you look at Towercast, the first two conditions here are clear. The merger has gone below the thresholds of the merger regulation. The merger has gone below the threshold of national merger control, so it has not been reviewed by any authority. But the court also adds, if you read the judgment, a third element, that the merger occurs in a market which is national in scope. And I think this is more interesting. Why does the court add this? So of course, that's what was happening in Towercast. The merger was national. It was affecting the French market and probably the French market only. But most mergers have transnational effects. Indeed, the whole legal basis for applying Article 102 is that the conduct has an effect on trade between states. So there is some supranational effect. So this last segment that it occurs in a market which is national in scope is a little bit puzzling because it seems to incapacitate Article 102 or to render it only applicable to a very small set of cases where there are no major cross-border effects. And that may be a more interesting problem with the way in which the court has canvassed this than the definition of what is an abuse of a dominant position when we got a merger. Just for completeness, I don't want to talk about this because it's not really interesting from an economics perspective, but I think what's interesting from an economic perspective is trying to work out when can you apply Article 102 to mergers, what's the scope of analysis there, is that these mergers that fly below the thresholds may also be referred to the Commission using Article 22 of the merger regulation, which allows a member state to notify the Commission of a merger below the threshold. The Commission has the discretion then to take it and review it. There is an appeal pending. Let's wait and see what the court says. The Advocate General was not sympathetic. But there appear to be two pathways, 102 or Article 22, to bring mergers back to the Commission's attention if they fly below the radar. So one of the clear implications in the reactions to this judgment is that you cannot reassess a merger that has been cleared. So if the Commission has said the merger is fine, you cannot accuse it of an abuse of a dominant position, except if the parties then abuse their dominance in a different way, but the merger is safe. But having read all the decisions on merger control, all the judgments on merger control, I came up with an interesting variation. What happens if there's an abuse of dominance before the merger? So suppose the dominant firm softens up the rival by a predatory pricing campaign or other exclusionary conduct. And at one point, the rival gives up, the market share collapses. And at that moment, the dominant company buys the guy. So you allow the merger because the merger itself, the act of acquisition, is not an abuse of a dominant position. But the monopolist had abused its dominant position in order to be able to acquire. Can you penalize them retrospectively for having abused their dominant position? The court has not said no. And the relevant judgment is Deutsche Post DHL from 2002, if I remember correctly, where the applicant said the only reason Deutsche Post had enough resources to buy DHL is because it was making monopoly profits on the protected market for postal deliveries, and it used those profits to subsidize the purchase of DHL. Therefore, the merger is incompatible with the internal market because it is based on illegal cross-subsidization. The court said no, only because cross-subsidization was not illegal. you can use your pot of gold to do whatever you like, provided what you buy is not anti-competitive, but using your pot of gold is not anti-competitive. But the court said it might be different if the excess profits had been made through an abuse of a dominant position. The court doesn't say what the difference would have been, but I think it's an intriguing scenario where you might clear a merger because it's not an abuse of a dominant position or it doesn't substantially beat effective competition, but maybe retrospectively penalize the parties for having abused their dominance in order to be in a position to make the acquisition in the first place. Again, I don't know if anybody has any interest in taking the case, but seems to me a possibility. Right. So summing up, what do we make of all of this? And again, I think here, as you said before, Heike Schweizer's words are going to continue to be important. And she says, look, we got very vague treaty provisions. The nature of the commission is a political body. We have now a huge debate on the more political approach, but what is fundamentally maintained by the court is the rule of law. The regime of judicial control, and this can apply to merger control. She was writing about 101 and 102. The regime of judicial control of the Commission's decisions contributes significantly to the state of affairs where the rule of law is sustained. And whatever you do with competition law, the fundamental objective is to maintain the rule of law. So the more economic approach needs to be contained procedurally. The Commission, if it uses economics, has to do so in an appropriate manner, giving the other party the chance to contest. Substantively, the court has to know what the legal standards are and can question whether the Commission is extending its jurisprudence. And also substantively in terms of making sure competition law fits within the scope of the treaty. So the court is putting boundaries on the exercise of judicial discretion so that it retains loyal to a fundamental value, the rule of law. That doesn't mean everything is rosy. I think there are a lot of problems in the case law, but the point is the court is doing its best to hold the Commission honest. But I think other actors need to step up. First, I think we need a new merger regulation. We've had a revision in 2004 because of the gap of unilateral effects, but we need a new one now. We need to clarify what the thresholds for notification are. We're seeing many member states now changing their thresholds to deal with below thresholds acquisition. The Commission needs to have a hand on this. We need to do better to integrate the merger rules with the new treaties. If you read the merger regulation, it refers to the treaty establishing a European Economic Community. We have a treaty of European Union. We have a treaty on the functioning of European Union. These treaty rules have changed quite significantly the ideas behind the economic constitution. So we need to make sure that the regulation is sensitive to these small, but in my view, significant changes. And also we need to make coherence with the foreign subsidies regulation. What is a competition problem? Well, there's a foreign subsidies regulation problem. We cannot have the Commission doing the same assessment in both cases. So I think a lot of legislative work is necessary to update the merger regulation, not to revolutionize it, but to update it. And the Commission also needs to do some homework. Okay, I wanted to put the badge up there because you cannot find it anymore. But around 2000, when you went on the website of the European Commission, there was the merger task force, and this is the badge they had, the sheriff, and there's a shark in the middle, right? And so this kind of gave an image of the commission. Yeah, we're after the nasty guys. You know, if you are going to merge, we're going to take care of you. And of course, after they lost 3 cases in quick succession in 2002, the badge completely disappeared. So did the merger task force. But to its credit, what the Commission has done since is create a set of guidelines by which it binds itself. And I think maybe this is an interesting comparative discussion when we hear more about the US. In my view, the EU issues guidelines as a commitment device. This is our analysis. We will force ourselves to follow these guidelines. And this protects it against attacks from people who want a more policy-oriented approach, but also from people wanting a totally different analytical frame. This is our framework, and we give this out so that we do not deviate. Or if we choose to deviate, we need to have a pretty good reason for doing so. But I think we need new guidelines simply because there's so much interesting economics literature has come out since 2004 that needs to be integrated, particularly in terms of clarifying unilateral effects, but also sometimes pushing back against silly things the court has said. So in Microsoft Skype, the Commission did not intervene in a case. And one of the arguments of the applicant was, look at the purchase price that Microsoft put on Skype. Look by how many billions they wanted to buy this tiny entity. And the court says, oh, the size of the purchase is not important. So what's important is the market structure, which in the 2023 guidelines in the US is quite different. Actually, that's a useful indicator that the merger may be anti-competitive if you buy a tiny rival for a lot of money. So I think there may be statements where the Commission guidelines can push back on because it's a dialogue between the court and the Commission as to how an appropriate economic standard is built. And I'm going to stop there. Thank you very much.